Welcome everyone. I, Dr. Abhishek Kumar Singh, Associate Professor, Faculty of Law, Integral University. On behalf of entire Faculty of Law, warmly welcomes you all in 30 days interdisciplinary faculty development program on the theme Emerging Trends in the Administration of Justice, Criminal Justice System, and Forensic Science. Today, we begin with the fourth technical session of Module 3, and the resource person for today's technical session is Professor Akhilendra Kumar Pandey, who will be addressing on the topic Cognitive Liberty and Criminal Control Framework. Professor Akhilendra Kumar Pandey is a distinguished figure in the field of law and academy. He currently holds a position of professor at Faculty of Law, Banaras Hindu University. His area of specialization lies in criminal law, criminology, reflecting his dedication to understanding and contributing to the intricacies of legal system. Professor Pandey also maintains a profound interest in the legal philosophy, adding depth to his intellectual pursuit. Professor Pandey embarked on his teaching career at Sikkim Government Law College, Gangtok, before further enriching his pedagogical experience at University College of Law, North Bengal University, Darjeeling. Over his illustrious career, he has successfully supervised 4 research scholars with 6 currently under his mentorship. With an impressive teaching and research career spanning 32 years, Professor Pandey has not only imparted knowledge but also actively contributed to legal research. Notably, he undertook a project on non-registration of FIR in Varanasi district in collaboration with Bureau of Police Research and Development, Ministry of Home Affairs, Government of India, New Delhi. He also concluded a pilot project on state of affair of family members of police personnel in Varanasi district under the same prestigious institution. His commitment to the legal community is further evidenced by his membership in esteemed organizations including Indian Law Institute, New Delhi, and Indian Society of Criminology, Chennai. Additionally, Professor Pandey has served a vital member of various school boards and institutions like Central University of Sikkim, Gangtok, Assam University, Silchar, Assam, and Mohanlal Sukhadiya University, Udaipur, Rajasthan. He also assumed the role of coordinator for legal cell at BHU and actively participates in various committees within the university. Professor Akhilendra Pandey is not only a luminary in the field of law, but also a dedicated educator and researcher who has significantly contributed to the legal discourses in India. We are honored to have him as our resource person for this session. We are confident that his insight will greatly enrich our faculty development program. Thank you, sir, for joining us. Thank you all for your attention. We look forward to a fruitful session with Professor Pandey. Welcome, sir.
Thank you, sir. First of all, I would like to express my heartfelt gratitude to the organization and particularly the organization team, Dr. Abhishek Kumar Singh ji and others. Uh, in fact, when I was asked to deliver lecture, it was my preference to speak something on criminal law. So I prefer to speak on cognitive liberty, particularly of forensic science, how it is being applied. So it was my choice, but I do not know because I am not so technological savvy whether the lecture is going to be of any use or not. But certainly, I would like to share with you some of the important things in this regard. I will come to the concept of cognitive liberty at the end of my lecture. But before that, I would like to share with you that law is not an independent autonomous knowledge. It derives its spirit from various branches of knowledge, including science. So the area for today's discussion is such where there is interaction between science on one hand, particularly bioscience, and law on the other hand. Therefore, I would like to start that why this particular topic was chosen. Its history with reference to India goes back to year 2007 when one girl student was prosecuted for offense of murder, and the evidence collected against her was on the basis of BEOP, that is what you call brain electrical oscillation signature, BEOS, not P, BEOS. So, on that very basis, she was found guilty by the court. She was convicted along with her husband. And the issue was that whether this kind of technological evidence be received for the purpose of conviction or not. This case happened in Pune, Maharashtra, and the judge was very much impressed with the finding of the scientist, neuroscientist, that it could connect the complicity of the accused with the commission of the offense by entering in her mind. So that was the real issue. What are the problems before us in accepting it? The first thing is that there are various methods of finding out the truth. Sometimes material evidence are not available. So we are interested in finding out some material by which we could connect the accused with the commission of the offense. So material evidence is not available. Accused is with us, our suspect is with us. So how to extract something from him? Now, if we see the existing legal provisions, then any confessional statement made to the police, that is not relevant. That confession has no significance. And the police is not in position to recover any material thing. What to do? So there is a dilemma whether the accused should be let free and crime be permitted to continue, or somehow the accused be connected with the commission of the offense and conviction be faced. So that is the prime reason we are discussing about it. Now, if we talk about the two important mechanism which has developed in last 20 years or so, that is of brain mapping, and another is functional MRI. So what functional MRI does is that there is a place in the human brain that is called hippocampus. It is deeply seated, and there memory resides, and that is illuminated the moment EEG is performed in that area, or MRI is performed in that area. So what happens that the subject, that is the suspect, he is placed on a table. About 30 electrodes are put around his head, and the moment the accused or suspect comes across a particular scene with which he is having in his memory, there is a special kind of light, or it starts beaming, the light starts beaming, suggesting that the accused is acquainted with the fact. And who can be acquainted with the fact? The person who was involved in the commission of the offense, he must be acquainted with the fact. So it is also called as experiential knowledge, knowledge which is based on the experience of the individual, because he was exposed to that photograph, that particular question, or that scene, which was prepared by the crime investigating agency. And the moment the person comes across that situation, there is some movement in the system, in the machine. So by that it is asserted that the person was involved, he or she knows that the crime was committed. So what happened in the case which I was referring to, the moment a question was put to her whether the deceased Bharti was known to her or not. So they were good friends, they were having good relationship. But later on, she changed her allegiance to another person, some Praveen Khandelwal, if I remember the name correctly. So Praveen Khandelwal and Aditi Sharma, they decided to dispose of Mr. Bharti. So what was done, that the accused called that deceased and provided sweet that was laced with arsenic. So question was put to her that she gave sweets to him in arsenic, and that consumption of that resulted into death. There was some movement, there was some lightning in the hippocampus region of the brain. So that was trying to suggest that the accused is acquainted with the fact and circumstances. Now, problem is that if we permit this, anyone to enter in the mind in such a manner, that is called, that you may call or you may not call as an invasion, but certainly with the help of electrodes, the accused person was interrogated, not voluntarily but involuntarily. Fortunately, what happened in Aditi, she had consented for going through BEOS, that is brain electrical oscillation signature. So she had consented, there was no doubt. But the point is that whether the technology should be permitted to such an extent to enter in the brain, why this problem is arising? This problem is arising because of the fact that our celebrated principle of criminal liability is that a guilty act coupled with guilty mind, if these two elements are proved, accused can be held liable for that offense. And it is the burden on the prosecution, that is state, on the investigating agency, to connect the accused with the commission of the offense along with the guilty condition of mind. So accused is not divulging anything. There is no material evidence. Whatever is there, that is in his or her brain, somewhere deeply seated. So it may be in his her experience, but there is no material evidence. And neuroscience, it is saying that it will change the scenario, particularly in the legal system, by entering into the mind. So if the legal system is likely to be affected by, by the intervention of neuroscience, then certainly it will be a great achievement. But at the cost of what? Whether autonomy of an individual is being interfered with or not. And important thing is that even the most developed countries like America, they have not accepted the intervention of machines in the administration of justice, and particularly convicting the accused on this very basis. Maybe light polygraph, light detector test, or other mechanism. I will come to that a bit later. But the point is that why this has attracted the attention of the law experts in this area. Reason being that man is not only in his body, rather man with corpus along with the consciousness. That is the reason man exists. So consciousness is important thing. If we take help of Kantian theory, then Kant will say that a person has a freedom to think, and he has unlimited freedom to think. So far as external body is concerned, it should not act in such a manner that it jeopardizes, it affects the freedom of another person. And the role of law comes here, that when one's action interferes in the freedom of another person, so law can control that. But law should not control, and law cannot control the mind of the individual. So what is in public sphere, that can be controlled, but what is going inside the mind, that cannot be. On the opposite side, there is Mill. Mill will try to say on his principle of utilitarianism, that every person is free to maximize his pleasure, and the law, particularly criminal law, will not come into picture unless and until the right of other person is harmed, or the other person suffers any harm. But when we talk about action, then certainly action is preceded by an idea. So not only the bodily movement, but any idea that can also be brought in the domain of criminal law if that is harming. So point here is that if we accept Kantian theory in this regard, that man is the body of consciousness, and consciousness cannot be invaded. So far as bodily movement is concerned, that can be controlled through the agency of law, and it will not be possible for law to interfere in the consciousness of the person. And it should not be the goal also. Now, point here is that if we start taking help of by neurological scientific invasions, then what will happen? That is one issue, and that too from the ethical point of view, legal point of view. If we have a glance of our legal system, our constitution in Article 20, Clause 3, that no person can be compelled to be a witness against himself. Number one. Number two, that if we see the provisions of Criminal Procedure Code, particularly Section 53 and 54, that says that it shall be lawful for the medical practitioner to examine the body of the person of the accused at the request of the police officer. But if we go by the explanation of that, then that explanation says explanation is in relation to material. Material thing means it may be hair, sputum, it may be nail clipping for the purpose of extracting DNA. That is another thing. So all the things are material in nature, and that can be permitted so far as the medical examination is concerned. Now, if we recall the most celebrated case decided by Supreme Court of India, that is Kathi Kalu Aughad case, then in that case the court said that taking of blood sample is a material evidence, and that can be taken. There is no bar. Accused is not being compelled to give evidence against himself, and that is not going to interfere in his right against self-incrimination. That was accepted. But when Srimati Selvi case comes, Selvi versus State of Karnataka comes, then it was said that invasion in the private domain, that is mental psyche, that is not permitted unless and until the person has given consent for it. So narco tests started gaining ground, and one company which is involved in making such kind of instruments that has reported that every week 3 to 4 persons they are interested in knowing what is the fate of this machine and this technology. So means people are interested in finding out whether the machine can be useful in the determination of truth or not. So determination of truth by interfering has brought the attention of the legal experts. So far as uh, scientists are concerned, physicists are concerned, they are of the view that there is no harm if machine is used for this purpose. If we take the help of novel written by George Orwell, 1984. In that novel, he has it is a kind of fiction, of course, but in that novel, he has pointed out that the time is not too far when thought crime will be detected and the person will be punished. Of course, it was a dystopian kind of novel, but the thing is that even the thought can be held to be criminal. Now, synchronization of a criminal act with criminal mind, that was hitherto based on the evidences available against the accused. And it was the prime function of the investigating agency to do that. But what will happen if we start accepting this kind of neuroscience, application of neuroscience or neurobiology in the area of crime detection? The first and foremost thing is that regarding admissibility, reliability of the evidence and admissibility of it. Now, reliability means the accused out of 100, all of them may be acquitted, but not a single person against whom there is an iota of doubt should be punished. In other words, we say that let 100% be exonerated, but one single person should not be convicted who is innocent. So innocent should not be. What will happen to this doctrine? If a person or the system is permitting the application of a neuroscientific uh, mechanism in entering the psyche of the individual, what is happening? Whether man shall not be entitled for his autonomy as to his body and mind, or we have to redefine ourselves that whether the cognitive liberty, that is right to think, right to express, right to not think, right not to express, or right to think but not to express, should it be left with the individual or should it be controlled by some external mechanism? That is the issue. Now, if we revert back, there is bioethics declaration convention. In that, it is provided that research in the biological area should go. There is no doubt about it. But at the same time, it should be synchronized in a such manner that the human rights aspect of the individual is not affected. Now, it is left with the system to see whether it can be done or not. So, one point is that reliability and admissibility of the evidence available by these mechanisms, these these technologies, uh, that is not 100% reliable. Attempt is worthwhile to make it reliable. There is no doubt about it. Initially, if we recall that what happened with DNA fingerprinting, initially it was not accepted, but later on it was accepted because it was proved that it was more than 99.99 recurring correct. Then court accepted it, but initially there was hesitation because the court is to appreciate the evidence, looking into the fact and circumstances, and reliability will be on the basis of the cross checking, because cross checking mechanism is not here. Whatever the scientists say or whatever machine says, that we have to accept it. There is no mechanism, so reliability is still doubtful. And so far as admissibility is concerned, what is to be admitted or not, that is the relevancy. Of course it may be relevant, but it may not be admissible. So that is the basic principle of law of evidence. uh, if we see the provisions related to international law, then at least we come across a declaration, that is Universal Declaration on Human Rights, that says that there is right to life as well as liberty. Same is enshrined in the Constitution of India also. And that also says in this perhaps Article 12 of the Universal Declaration of Human Rights, that there is freedom of thought and freedom of expression. So freedom of thought and freedom of expression, how it can be maintained if the mechanism is such which is interfering in the thinking process? One should think in this way or that way. It should not be in the hands of the machinery, in the hands of the state. If it is so, then the development and evolution of the society will come to an halt. If we take the help of American laws as to DNA profiling, initially when an act was made in year 2000, at that time it was provided that those who have been convicted, then their profiling should be maintained. Subsequently, those against whom there is a case under investigation, that should be. Subsequently, the law was extended in year 2005 that this DNA profiling can be made in respect of any person who has been arrested. It means that in 5 or 6 years, the experience suggested that so far as DNA profiling or DNA test is such, which has got a credibility, which is reliable, and it may be admitted. In India also, we are having several cases where DNA profiling was accepted as a valid evidence. It was made admissible. But still, we have to decide whether information which is the experiential regime or domain of human mind, that can be treated as a real evidence, or it is only an imaginary evidence that is to be decided. I feel that it is not a real evidence. It is intangible and it is imaginary evidence. It has to establish itself that it has crossed the domain from being imaginary to become real. Now, this is one aspect. Another significant aspect is that in any criminal trial, what is expected? It is provided in the Universal Declaration of Human Rights as well as Constitution of India, maybe other countries as well, that fair trial is one of the important components of administration of justice. Now, what is fair trial? Fair trial that the court should be independent, impartial, number one. Accused should be held to the base evidence which is against him, and that is connecting the accused beyond all reasonable doubt. It is not based on preponderance of probabilities. It is based on actual involvement of the accused in the commission of the offense. If the evidence is such a clinching evidence, then only accused can be held liable, otherwise not. Now, this is one thing. Another important thing is that when a judge is looking at the screen, watching the screen, that when this particular question was put to the accused, how the hippocampus region of his brain started illuminating. Now he will be dazzled by this experience. So, how can we say that the judge will remain impartial? He will be influenced by this kind of thing. To him, this is magic, but science should not be magic and it cannot be magic. So long as it is in the domain of magic, it is not science. So, point here is that neuroscience, it has made a successful journey in the direction, but still the lawmakers, the policymakers, they have to think regarding it. That is, that the autonomy of the individual should not be altered or interfered with. The another important aspect which I would like to share with you, that so far as uh, polygraph test is concerned, what is polygraph? There are various parameters. Questions are put to the suspect, and if there is any change in his physiology, that is recorded. Okay, why it has not been made admissible polygraph test? Reason is that it is tentative. It is not always. Sometimes a person may not be involved in the commission of the offense, But when the same question is put to him during polygraph test, he may feel upset. His parameters may be fluctuating. So how can we say that because there is some fluctuation in the parameters, and therefore he is involved in the commission of the offense? That does not hold good for polygraph test. Another important aspect is that we should go by the principle of reasonableness, that when evidence is brought before the court, it is the court to assess whether the accused is innocent or he is criminal or he has committed crime. So, is this determination has to be done by the jury, by the judges, whether the person is guilty or innocent. Machine cannot be used for the determination of guilt or innocence. Machine has got its own limitation. Of course, it may be an indicator, provided other circumstances reasonably prove independently that the accused is involved in the commission of the offense. So, for determination for us, point for contest for us is that the liability should his conduct, external conduct, as well as his mental thought. So, bodily conduct or movement is the direct result of the thought. But collection of this thought by adopting a mechanism machine, that has been a question of concern. The other important aspect is that uh, when we talk about the what you call uh, uh, about reasonableness. So governmental interest may be in the conviction and the punishment of the accused. But what about the interest of the individual? That is important thing for us. So one thing is that whether the person has been compelled to give evidence or he has volunteered to give evidence. The entering in the domain of mind by the machine, that is a sort of compulsion. The person was compelled, and it cannot be permitted by law. The real domain of what you call MRI, functional MRI, is that the neuroscience should control. Hello, hello, hello. The neuroscience should control the human behavior. Our man should be let free to think. He should be autonomous in his thinking. He should be autonomous in expressing. He should be autonomous in not expressing. Should we go by that principle, or machine should regulate the conduct of the man that it is interfering unduly? So that is the issue so far as MRI and functional MRI and brain mapping is concerned. Uh, One case was decided by the American court, uh, that was of an assault which was made on uh, uh, Ronald Reagan at one point of time. That was of John Hinckley. At that point of time, also MRI was conducted, and it was his ethnicity with the commission of the offense be considered. At that point of time, the court took the evidence on record, but to show that the accused was having schizophrenic state of mind, and because of that schizophrenic state of mind, he should be dealt with some leniency. So the court has taken that into consideration for the purpose of showing leniency. Or other cases are there where the court has accepted PET scan, MRI, or other technological know-how, but for reducing the degree of culpability, not for the purpose of holding him responsible. When it has been established by evidence, real evidence, that the accused was involved in the commission of the offense, at the time of the determination of sentence, whether the person was suffering from schizophrenia or he was having a small cyst in his brain, because of that he was not in the control, he was having an impulse, irresistible impulse, because of that malady, uh, that has been taken into consideration, there is no doubt. So point is that technological know-how and its development in the area of therapeutic science, that may be appreciated. The treatment of the patient on the basis of these findings, that may be good. But relying solely on the technological know-how by entering into the brain has issued certain legal and ethical questions. Ethical question is only one: whether law should intervene in the autonomy, in the permitted to interfere with the brain, mind, or law should control only the external behavior. Because if we start intervening in the mind, the time will be not too far when the machine and the system will be controlling the human mind also. And if human mind is controlled, then the process of development, growth, evolution, thought process, that will be curtailed. Reason being that whenever a person starts thinking afresh from a new direction, then that may be criminal according to that state of criminal law in that particular state. For example, when it was said that it is the earth which revolves around the sun, not the vice versa. At that point of time, the person who said that it is earth which revolves around the sun, not the vice versa. So the very thought process which came to his mind, if it would have been punished at that point of time because it was against the religious thought, religious practice, religious belief of the individual of that particular state. So that theory could have never come on the surface, or such kind of unique idea could have never come on the surface. So point is that if through mechanism of law we are interfering in the domain of a thinking process, that will be a great assault, a kind of assault on the thought process and autonomy of the individual. Uh, there was one conference held at Milan, uh, uh, and during that conference, it was said that neuroscience neuroscience has to be synchronized with the human right concept. It means that neuroscience development is acceptable to us. It may give us a great service in times to come, but neuroscience should not contravene, should not affect adversely the human rights. Now, from whatever discussion we had, that discussion is basically standing on two pillars which are diametrically opposed to each other. One pillar is that man is not destined to nature, rather, man makes the nature and lives in that nature which has been created. So, on the one hand, that it is the nature which destines the man, on the other hand, it is the man which destines the nature. So, which of the two pillars should be accepted? Why not we accept that nature can be interfered with to the possible extent so that man lives in that state of nature? Man cannot remain outside the nature, and nature cannot be imagined beyond man also. So why not we should start thinking in the direction that the nature and man, they are synchronized with each other. The another aspect which I would like to share with you is regarding bioethics declaration of year 2005. This bioethics declaration again, it is insisting that neurological science it should develop, but again it should not interfere in the domain of human rights. There is also a society for neuroscience called SFN, uh, that is responsible for making social and policy implementation program for neuroscience branch, neuroscience research. So how the neuroscience should be synchronized with the policy so that and the society that it is not interfering too much in the individual autonomy. So whatever body exists, maybe at international level, particularly of human rights activists, of neuroscience engaged in research and development, they are of course thinking about it that neuroscience should develop, but not at the cost of human rights interference. Human rights should not be violated. So, if we restrict our definition of human rights to two important components, that is uh, uh, freedom of body, security of body, and and freedom of thought and expression, then this right is likely to be adversely affected. And the case with which I started of Aditi Sharma, that was subjected to a lot of criticism throughout, that an ill-based evidence was considered by the it was court of session, district court, and that court punished the accused for life imprisonment, both the accused for life imprisonment. But what for conviction, the evidence which we are expected to be that it should be beyond all reasonable doubt, that could not be established, that could not be brought by the investigating agency, except that was brain mapping. So that was the issue uh, on the basis of which it was criticized. Uh, then the other point which I have discussed and I have indicated, rather not discussed, I have simply indicated that if court chooses to admit a neuroscientific evidence before establishing the guilt of the accused, neuroscience can be used at two levels. One at the time of determination of guilt, and at the time of determination of quantum of sentence. So at the time of quantum of sentence, the court, particularly American court, even Italian court, it has accepted that it may be considered for determination of quantum of punishment. But so far as determination of guilt is concerned, the court has to remain sure, and it has to assure doubly that whatever evidence is being produced before it, that is not only independent, it is reliable as well. So this reliability dimension of the evidence in neuroscientific development, that is still in the stage of confirmation and validation. There is one person who is involved in brain mapping and functional MRI company. He is associated with that. He's president of that. So he is saying that a day will come when we will be able to establish that this neuroscience machine that is going to be 100% correct. There will be no doubt about it. But let us wait for that. But so long as the credibility, reliability of that machine is not established, we should be slow in admitting such kind of evidence uh, in the administration of criminal justice. Otherwise, what will happen if all the things can be done by artificial intelligence? So, if artificial intelligence is there, what is the need of man? Why man should be there? That may result into another question, big question. Why system should be there? all the man agency should be replaced by me- mechanical components. So that is the thing which we have to ponder about. And the last but not the least is that uh, this neuroscience should be viewed like a science. And if we take the example of Newton theory of gravitation, law of gravitation, then that theory is hold is still good substantially, even after several hundred years. But if it is not like that, what happens in functional MRI? That if a particular question is put, light start beeping, or it illuminates. Now, if it is so, to man like us, to a common judge, it is no more a science, rather it is a magic. So neuroscience has to establish itself as a science, not as a magic. That day has still to come, and let us wait for that. Sir, there will be any question, a question session also? Hello.
For you. Uh, One question
Hello.
is, sir, that, sir, am I audible?
So yeah, very much.
Okay, sir.
Sir,
Sir, there is question round session at the end of every
uh,
session.
no,
So
no,
there is
should
one
I continue for
question.
some, sir?
Sir,
Sir,
if you
sir.
want to continue, you can go ahead.
No, whatever dimension I was to discuss, that dimension I have put before you. If there is
Okay,
any
sir.
question from your side, then that will be welcome.
Yes, sir. Definitely, there is one question from one of our participants that,
Sir,
sir, in this era, the science, there is great emphasis on the research, and at present, neuroscience is developing at a very high speed.
please.
And while they are developing at such pace, they are definitely interfering with the cognitive liberty of individuals. Because how can we achieve this balance that neuroscience shouldn't interfere with the cognitive liberty of individuals?
Okay, how to maintain cognitive liberty on one hand, and use of technology, and particularly neuroscience technology, that can be synchronized and balanced. That is your question. So one thing is that if we accept the Poundian theory of law, that there must be balancing of interest. Now it will be matter of policy for us whether individual autonomy should be compromised, or we should punish a person who has been held guilty not because of any independent evidence, rather because the machine has entered into his mind and that is being extracted from him. So whether man should be an individual to be praised, or man is simply a guinea pig on which certain experiments be permitted. It will be a matter of policy, of course, number one. Number two, that we have to change the basic fundamental principles of criminal law, that now the law should permit to interfere, to intervene in the mind. And of course your constitution permits that no person shall be deprived of his life and personal liberty except according to procedure established by law. You can make the procedure, but the thing is that will it be called just, fair and reasonable? That test has to be complied with. And I do not think that man can ever be treated as a guinea pig. So if there is no evidence, I think that let the person be acquitted instead of being punished. Because what will happen? My point is, my concern is that, so if I have been put with a question which is very much disturbing, so what will happen to BEOS, what will happen? What will happen to functional MRI? There will be some disturbance. There will be disturbance in P300 oscillation rate. So if that is there, not because the fact that I was involved, because I am personally so excited with that situation that there is variation. We cannot tilt it. We cannot establish that whether this variation of because of my involvement in that case or that narration of that case has affected my physiology in such a manner that my parameter went what called array. It deviated from the normal side. So that is the issue. So long as we are not in position to say that this mechanism is 100%. Number one. Number two, it will be a matter of policy whether to intervene in the mind of other person just in order to elicit certain information from him. If it is so, then we have to bid goodbye to individual autonomy of his thought process, of his expression, and nothing will come out independently from the autonomous body. It will be the state which will shape whether the act is a crime or not a crime. The moment you start thinking that it is the earth which revolves around the sun, while your faith belief says that it is just the river, you will be subjected to punishment because one state of particular brain, one particular part of the brain is stating to you that if I tell the truth, then certainly I will be punished. If I suppress the truth, then I will be acquitted. The moment this conflict comes, suppression of fact and suggestion of false, your mind becomes deceptive. Machine will catch it that your brain has become overactive because on the one hand you are suppressing, on the other hand you are suggesting or you are speaking something false. So your brain activity will be doubled. That will be a significant change in the human mind. But the point is that whether autonomy should be accepted or it should be compromised. So it will be matter of policy. And I think so long as the mechanism, this method becomes 100% true, it is not advisable to interfere in the mind of it. At least that autonomy should be given by the state. And I believe that even today, after 250 years, Kant holds valid argument that law should control the external human behavior, not the internal thought process. I go by Kantian theory. I think that all of you will agree to that.
Thank you, sir. Very well explained. Uh, Thank you for being the part of this faculty development program, sir. And we are also looking forward for our future association. We request you, sir, that in the coming days, that you should cooperate with us, you should associate with us in our other future endeavors. Thank you, sir.
No, I am very much part and parcel of your institution. So nothing like that. I am always with you as and when you will direct me, I will be there.
Thank you, sir. Thank you. Thank you very much, sir.